matter of quite old children.
Mr. Ejezia, we're sorry to have kept you all a few minutes. Can I say two things by way of preliminary? The first is, I'm sure everybody in this court knows the identity of the children is protected by the usual anonymity order. If any names are referred to in the course of the hearing, that is not to be publicised and reported by anyone outside the court. And perhaps linked to that, we understand that arrangements have been made for this hearing to be live streamed. Does either of you have any objection to that continuing?
No from me, my lord.
My lord, no, thank you.
Right, very well. Right, yes, Mr. Ejezia.
My lord, just before I begin, I just let my lords know that I had discussed with my learned friends on the need to maintain the ABC as the name of the children, the way Justice Peel used it in his judgment. At least that, and that will help us in protecting the identity of the children. Having said that, by way of housekeeping, may I confirm if my lord and have the core bundle? There is a core bundle.
We have a core bundle, supplementary bundle, an authorities bundle, and a submissions bundle containing your speaking note, skeleton argument for the local authority, and skeleton argument for the children's guardian. So that's what we have.
Yes, my lord. My lord will be familiar with the facts of the case and also the chronology, which is on page 30 of the core bundle. I would just wish to emphasize just the key date. First, that the child involved, that's child B, sometime in 2018, was found to have multiple injuries. And the doctors alerted the social workers and the police got involved. And the local authority commenced care proceedings. That led to, in April 2019, child C was born. And another care proceedings were also commenced. Then that led to a 5-day hearing starting from June 2019 before His Honor Judge Booth. Eventually, on the 14th of June 2019, the final care placement order was made. And following that, potential adoptive parents were notified to the children. And on the 15th of October, the first application was made for the adoption of the last child, C. Then on the 28th of January 2020, application for adoption was made for the adoption of A and B. I needed to clarify that because there was an issue as to the actual date, and the fact about the application for A and B was missing in my chronology, initial chronology. It was later discovered that their own application for adoption was made on the 28th of January 2020. My lord will also notice that the mother made an appeal.
Sorry, I'm looking at the, forgive me,
Yes, my lord.
I'm looking at the chronology on page 30.
Yes, my lord.
And are you just putting another, did you just put something in there that isn't there?
Yes.
Just tell me what that was, would you?
That's on item 29, 26, my lord.
So that's there. That's the new item.
It's not. No, it wasn't included. I'm just making including it now.
Yes.
That application that was made on the 15th of October,
Yes.
2019, only related to C.
C. Yes.
So then the application for adoption of A and B was made on the 28th of January.
28th of January. So I should put that as a 27A.
Yes, ma'am.
28th of January 2020.
2020.
Adoption applications for A and B.
Yes.
Thank you.
Yes, ma'am. And those applications were, before then, the mother had appealed against the final placement order and lost the appeal.
Yeah.
Also, the mother made the presentation, which Judge Booth considered to be an application to oppose the making of an adoption order.
Yeah.
A hearing was conducted on the 20th of February 2020. At the end of the application for mother to oppose was rejected.
Yeah.
So, mother also appealed against that decision.
Yeah.
And eventually lost the appeal by the order of the Court of Appeal dated 26
Of March.
March 2020.
Yep.
Then the road was clear for the adoption hearing on the 6th of April.
Yes.
In accordance with the rules, the mother was given notice of the hearing, but because of the coronavirus that emerged, pandemic that emerged at the time, the hearing was then converted to, the face-to-face hearing was converted to a remote hearing by telephone. And the mother was notified, and she was preparing to attend the hearing by telephone.
I was just trying to remember, Mr. Ejezier, where we were in the pandemic. So this is the 6th of April.
Yes.
So that was about 2 or 3 weeks into the first lockdown.
Yes, my lord.
When we were all of us, getting used to how courts were going to work.
Yes, my lord. But to be fair to Judge Booth, he took a very sensible approach.
Yes.
By then converting
Yes.
the face-to-face, the hitherto face-to-face hearing to remote hearing.
Yes.
But my lord, what then happened was that the mother received a text message. I don't know if my lord will want me to show my lord the text message she received from the social worker. That's on the core bundle. My lord, it's on page 114 of the core bundle.
So Debbie Wood is the
Social worker, yes. That notified the mother of the remote hearing on the 6th
Yes.
of April 2020. Then what then happened was that, if my lord will go to page 115, the last text message there on the 1st of April, the same day, was then what I will call a reversal message, telling the mother that Judge Booth is excusing all parties from attending the hearing on Monday. There will be no telephone hearing as previously directed.
Mr. Jay-Z, could I just ask you this? You've said that the approach adopted by the judge to have a remote hearing, you you make no criticism of that. Had it been followed through?
Had it been true, I would make little criticism. I was answering to my Lord's question as to because of, at the time, we didn't have guidance. We were all confused to some extent.
Yeah.
So in that context, I wouldn't have so much criticism, save to the fact that how we need to be satisfied that the judge himself was also satisfied that the mother could participate effectively. That's the only limit I would have some criticism. If only, but if at that time the judge was satisfied that the mother could effectively participate, then I wouldn't have any criticism. And if the mother indeed participated effectively, I wouldn't have any criticism so much. But the problem I have is that the way things turn around, and having said that, my Lord, we see that an order was eventually made, and that order is on page 161 of the core bundle under tab 4.
Just before we leave the situation on the 1st of April and the 6th of April,
Yes.
just been in a completely different appeal which concerned things which happened in the early stages of the pandemic. I think to some extent we can all recall what happened. The unofficial lockdown, 16th March, Prime Minister's announcement of a lockdown, at that stage a very severe lockdown, 23rd of March, Coronavirus Act, 25th of March, regulations, 26th of March. And after that, for a while, there were just about no live court hearings at all. And also the technology for Teams, Zoom, Skype for Business, all that sort of thing was hardly underway. So it wouldn't be surprising if a judge directed a hearing to take place remotely by phone. As I recall, that's about the best that was available at the time. One has to be careful about taking judicial notice of things, but have I got it right?
My Lord, to some extent, but I just need to complete it and also give my own personal experience that round about that time, I also had a hearing, though in the High Court. By then, we were using Sky for Business.
Yes.
Sky for Business was the first one used before it was eventually developed to MS Microsoft Teams.
Yes.
I think there were also some other courts that tried to use Zoom, but there were complaints raised about that. So
we weren't allowed to use Zoom.
okay, so I know there was.
The bar wanted to use Zoom, but we got messages that we weren't allowed to.
Okay,
I'm not speaking out of turn, or giving evidence, but that's certainly what happened. But you're right, it was Skype for Business in the early stages, and also, as I recall, a greater use of telephone hearings, particularly by the district bench in the early months, because of concerns about the adequacy of video technology.
Yes, my Lord. Thank you, my Lord. I was trying to draw my Lord's attention to where the order is. The adoption order is on page 161 of the bundle, just behind that 4. That is the order that's in contention. I needed to draw my Lord's attention to it because then I'll go back to follow my speaking note in making my submission. Now, then coming to the submission bundle, my speaking note is on that tab 1. Now we see that based on my Lord Justice Baker order dated 9th of April 2021,
Yeah.
that is the order granting permission.
If I may say so, your speaking note follows my directions very precisely. And
Yes.
For my part, I'm very grateful to you for doing it.
Thank you, my Lord. So, my Lord, the first issue we identified is was the adoption order regularly, lawfully, validly, or properly made? The second issue is, if no, what should the Court of Appeal do? Then the ancillary issues, the third one, when should the adoption order be revoked under the inherent jurisdiction as opposed to appeal? What arrangement to make when making adoption order during the pandemic?
Yeah. C and D are really subsidiary issues.
Yes.
Particularly D. I no doubt you're going to focus on A and B.
A and B, yes, my Lord. Yes, my Lord. Thank you, my Lord. My Lord, on the first issue as to whether the adoption order was properly, regularly, or lawfully, or validly made, my submission is that no, that the adoption order was not regularly, validly, lawfully, or properly made. And the reason I say that is clear from the law. First, my Lord, if I may take my Lord to authorities bundle, if my Lord will permit me, on page 133.
So the page number again?
133 of the authorities bundle. That's the case of OA, a child, human fertilization and embryology, adoption revocation, 2016 EYHC 2273. My Lord, the point I wanted to take, my Lord, is it will guide all of us. You know, I know it's a point that is where everybody is familiar as to what it means in order to be valid or in order to be regularly made. But the point was clearly made on, if my Lord would go to page 138. That the judgment of Sir James Mumbi.
Yes.
You will see where paragraph 27, but I'm looking at item 4, as to give us an insight as to what it means to say that an order is regularly made. It says an adoption order regularly made, that is that defined what it means regularly made? That is an adoption order made in circumstances where there was no procedural irregularity, no breach of natural justice, and no fraud, cannot be set aside either on the ground of mere mistake. So at least he gave us 3 definitions of what amounts to a regular order. That is, that order must not be in breach of natural justice, there must not be element of fraud, and that order should not be procedural irregularity. But our submission here is that the adoption order made in this case was not regularly made. It was not regularly made because the procedural requirements were not met. And if my Lord will permit me to take my Lord to the authorities bundle regarding the procedural requirement in this case, that is section, first I'll start with section 46
Yes.
of the Adoption and Children's Act 2020, some authorities bundle, page 212. My Lord, I'm talking about section 46, subsection 6. My Lord, we see that it says before, I'm adding emphasis there, before making adoption order, the court must consider whether there should be arrangement for allowing any person contact with the child. And for that purpose, the court must, my Lord, emphasis, must consider any existing or proposed arrangement and obtain any views of the parties to the proceedings. So, my Lord, in the event, what happened on the 6th of April 2020 did not meet this requirement.
Well, can I just test that?
Yes, madam.
The judge would have had before him the adoption papers,
Yes,
which would have included the Annex A report.
Yes, madam.
And in that report, I think, we don't have that, obviously, do we, for the purposes of this hearing, because you haven't.
No, that hasn't.
And that will have dealt with the question of contact, I anticipate, and is part of the formula, the standard form for the Annex A reports. And correct me if I'm wrong about this.
Yes, madam.
There is a place where the parents' the views on adoption, on contact, post-adoption, are supposed to be set out. That's what I think would normally happen. So the judge would have before him evidence about the views of the parent about contact. Would he not?
My Lord, that is something that I wouldn't, unfortunately, perhaps it might be there, but I wouldn't say it with conviction that it is there.
Well, let's just take it a stage further.
Yes.
There are many cases, probably most cases, where the parent doesn't attend the actual adoption hearing.
Yes, my Lord.
Particularly if he or she's been refused leave to oppose.
Yes, my Lord.
But the judge still has the statutory obligation under section 46(6) to consider the question of contact and must obtain the views of the parties. And on top of that, there's the section 51A obligations.
Yes.
So that's why the forms require for this issue to be ventilated on paper, not just at the hearing.
Yes. Okay, my Lord, I taking off from there. Let's assume for the purpose of argument that the judge had a report containing the views of the parents at the time. But the problem we will have is that if you look at the adoption order I just showed my Lord on page 161, nothing in there shows that the judge gave any consideration to the views of the parents.
Oh, Lord, no, you're right.
Yes.
There's no recital to that effect.
Yes. And my Lord, one more thing is the president guidance made it clear that there should be a judgment, which either given on the day of the hearing or subsequently. What we got here is just the order. And one can understand, because I say that this is a very peculiar case. I've read authorities. I haven't seen a similar case to it. Because this is a very peculiar case in that even if the parents did not attend, nobody was in court to address the judge. Nobody was in court to address the judge, to assist the judge, because by law, the judge is supposed to consider the welfare of the children at every point in time, even at the point of making their adoption. And I must say one thing, my Lord, is that even at the point of making adoption hearing, the judge will also have to consider whether adoption is the only alternative. There could be longer foster caring, but we cannot say that on the record we have. And I can say you that why that is so is because nobody appeared before the judge to address the judge. So in our humble submission, the adoption order did not meet the requirement of Section 46, 6 of the Adoption and Children's Act.
Isn't Section 46.6 a requirement for the judge to consider whether, in this case, birth parents should be allowed contact? It's not, it doesn't say, before making an adoption order, the court must consider whether an adoption order should be made at all. I appreciate you say that's part of the process, but it's not a statutory requirement from Section 46.6.
Yes, Melody, Melody is correct that it doesn't say before, it doesn't relate to the substance of the adoption itself as to whether it should be made or not. But if I take, I must say, would I use this word? I rely on the word before. Melody,
Your point about the requirement of the judge to consider what he should consider is based on Section 1, presumably. Whenever a judge is making a decision or an agency about adoption, they have to have the child's welfare throughout his life as the paramount consideration.
Yes, ma'am.
And have regard to the factors in the checklist.
Yes, my lord.
So that's, you're right. Of course, in this case, a placement order had been made, and the question of whether adoption was the right course for these children had been considered at that stage.
Yes, my lord.
And the placement order could not have been made unless the judge had been satisfied that that it was the right order for the welfare of the children, but also applying Re B and Re BS that it was nothing else will do, to use the shorthand.
Yes, ma'am.
Last resort.
Yes.
So that although you're right that the judge had to have it in mind, we have to remember that had all been gone through at the placement order stage.
Yes, but my lord will also note that requirement is a continuous requirement until the end. The placement order was made on the 14th of June 2019. If one should look at 14th of June to 6th of April, that is a long time. So that would have been a change of circumstances. Of course, the more advanced one, which both the family court and the Court of Appeal did not agree with. And also, my lord, we also see that during the during the application before the High Court, the extended family members put an application. Unfortunately, it was not granted. But in one of them is that there is an argument about changing circumstance that had happened in one of the wider family members.
Yes. Now, Mr. You're beginning to, it seems to me, I say so, to very skillfully, I say so, bring in the matters which I have, which you weren't given permission to.
Yeah, I understand, my lord. I apologize.
Can we I think we need to focus on the irregularity which you have identified.
Yes, my lord.
And the question is whether it comes within the definition of procedural irregularity.
Thank you,
sort which should lead us to revoke the order.
Yeah. Thank you, my lord. The first point I've made the point.
Just a minute.
Yes.
You referred us to Sir James Munby's well-known decision and the phrase at item 4 of the relevant paragraph, in circumstances where there has been no procedural irregularity. I'm going to ask Miss Cheetham to give us a yes or no answer, not developing it. Are you saying that this is a case in which there has been no procedural irregularity at all? seems to us that the skeleton argument is tiptoes around that.
Lord, we say there hasn't been a procedural irregularity.
No procedural irregularity
Yes.
at all. Right. Okay. Thank you.
Thank you, my lord. Having made a point about section 46(6) of the 2002 Act, the second irregularity that happened, and the second point I want to let my lord know is on about section 141 of the 2002 Act.
Yeah.
That requires the rules to provide for notice to the birth parent.
Yes.
That is on paragraph 3. Says, in a case of an application for a placement order, for the variation or revocation of such an order, of an adoption order, the rules must require any person mentioned in subsection to be notified.
And that's what the rules do.
Yes, that's what the rule did. Then that, I will come back to the point I'm looking at back. Then, my lord, we see the rules are on page 219 of the authorities bundle.
Yes.
1415. Rule 1415.
Yes, ma'am. My lord, we see that
And 60. And 60.
and 16. Rule 14.15 relating to notice was complied with. In this case, the mother was given notice of the date and the time of the hearing. But what then happened was that if my lord will look at rule 14.16, that gives the mother the option to decide to attend the hearing and to be heard, subject to the limitations in there, because the mother has been refused leave to oppose the making of the adoption order, she couldn't have been heard. But I would say, as we said before, she could have been heard on the section 46(6) point as to the arrangement, what her views are as to the proposed, existing or proposed arrangement for
But
the...
her right to attend is not just for that purpose.
It's not just for that purpose. Yes, my lord. It's not just for that purpose.
It's a right to attend.
Yes.
Unqualified.
Unqualified, my lord. Unqualified, I'm grateful, my lord. Very grateful. It's unqualified. And not only that, my lord, even though that we are in the family court settings, there's still element of the requirement that transparency, openness for court hearings, notwithstanding the restrictions around family court proceedings. That might be the reason why at least the mother should be given, or the parents should be given the opportunity to attend and see what has happened, so that they can go home and tell their story. So this is what happened at the hearing, and this is what happened to my...
Well, it's a life-changing change of status.
Yes, ma'am.
And I've had an opportunity just to look back. I can't find, I've not gone back to 1949 or 1926, but certainly the requirement, the right to attend the hearing goes back beyond 2002 and the current act. So it's well established, long established, right of a parent to attend.
Thank you, my lord.
These hearings.
But my lord,
Can you help me with one more thing, Mr. Jose? I haven't got my lord's degree of experience of adoption, nor yours, nor Cheetham's, but I did look at section 51A, which is not in London, I think. The birth parents can apply for leave to have contact with the children post-adoption. And as I understand section 51A, it's not a requirement that they lodge that application at the hearing, so that the right of which your client has been deprived, is not the right to make an application about contact.
No, my lord.
No.
No, my lord.
It's the right to attend a hearing at which a life-changing decision is going to be announced.
Yes, my lord.
Yes.
And my lord, and also is the fact that in my submission, there is a public policy point to be made about a hearing to be made in the public. Given the life-changing decision to be made, in my humble submission, it is wrong to make that decision on papers. My lord, coming to rules 14.16, my lord, we see that within that rule, having followed or complied with rule 14.15, rule 14.16, nothing in that provision gave the family court the power to then set aside the notice or cancel the notice given. Nothing in there was gave any power to the circuit judge.
Well, speak for myself, Mr. Jay-Z, but
Yes.
I think you could extend your argument a little, because 1416.4 gives the court the power to direct that anyone must come. 1416.6 says that the court cannot make an order unless the applicant and the child attend, but then that can be qualified by the power under 1416.7, where the court may direct that the applicant or the child need not attend.
Yes, madam.
But there is no power to direct that the mother, in this context,
Yes, ma'am.
need not attend.
Yes,
So that the rule specifically contemplates a power to direct that some people need not come,
yes,
but does not give a power that the party, the mother in this instance, need not come. It's outside the explicit language of the Act. And we can all quote the Latin tag if we need to.
Thank you, my lord. Just to add to that point, if my lord, we see on page 220 of the authorities bundle, that is subparagraph 9. In terms of representation, it said the court cannot make a placement order unless a legal representative of the applicant attend the final hearing.
Yeah.
So I know it's an adoption order.
Say again.
It says the court cannot make a placement order unless a legal representative of the applicant attend the final hearing.
Yes, sorry, which paragraph are you looking at? Which?
That's paragraph 9, subparagraph 9 of
1469. Thank you.
Yes, I'm talking about page 220, my lord.
Thank you. Thank you.
Sure. My lord, that sums up my submission on the procedural irregularity.
Yes.
Just to take it a stage further, yes. Miss Cheetham refers to the early paragraph of the rule 1.4.2, which is part of the overriding objective, which empowers the court to deal with a case without the parties needing to attend court, and also to rule 227.3, which which provides, unless the court directs otherwise, a party shall attend a hearing, unless the court directs otherwise. So, but it seems to me, subject to anything else she may say, that those give the court the power to dispense, to set aside a party's obligation to attend court.
Yes, my lord.
But do not affect a permissive provision of the sort that you rely on here.
Yes, my lord. That's correct, my lord.
So there was no power for the judge to set aside, you say, override your client's right to attend.
Yes, my lord. Because, my lord, we see that, that this is not just a case of mere procedural irregularity. It has effect on the rules of natural justice as well. Not only natural justice, also has effect on our age-long principle of public hearing. because what it means is that the court, having done that, has cleared the way to sit in the comfort of the chambers, make an order as the court deem fit. And if we allow that to happen, it might not sit well in our family justice system.
Adoption orders should not be made in private.
Yes, yes, my lord.
In the sense that on the papers.
Yes.
They're not made in open court, but they should be made at a court hearing.
Yes, that's my submission, Lord.
Yes.
Thank you, my lord. My lord, that brings me to the second issue, is that if my lords are in agreement with me on the first issue, the question is that what will this court do? And I've set out my position on that.
Yes.
Is that the right of the child to be adopted by a fair, regular, and lawful adoption process is inalienable. It cannot be derogated from. It's absolute. And in that, I cited the statement by Heading J, and she made it clear. And if my lord will permit me to take my lord to the page, it's on page 250 of the bundle.
Yes, if this applies to other citations from authority, if all you want is the paragraph that you've put in your speaking note, we'll take it from you that that's what Mr. Justice Hayden said. If you want more context, then
no, that's what I wish. Before my lord will permit me to read that, he said,
of course.
Yes. I'm profoundly conscious of the impact of my decision on both the birth parents and the prospective adopters, both of whom will be distressed and unsettled by this uncertainty. I would, however, emphasize one important and, in my judgment, inalienable right, namely that of J to know in the future that the process by which he may have been permanently separated from his family was characterized by fairness, detailed scrutiny, and integrity.
But the extent of the procedural irregularity in that case was much more substantial than in this case.
Yes, my lord. But procedural irregularity, my lord, is procedural irregularity. That's the point.
That's where for my part, I think you've got to make your case.
Yes, my lord.
Because there are obviously I'm not in any, this was the moment somebody named Ms. Cheetham says, seems to me there was a procedural irregularity here. But not all procedural irregularities would lead to the revocation of the adoption order.
Yes, my lord, I made that point. This is a fundamental procedural irregularity, because what it has done is has touched on two fundamental principles of our judicial system: the rules of natural justice, right to be heard, and also the rules relating to public hearing of cases. Notwithstanding that we are dealing in a family justice system, there's still a requirement that at least one or two persons could come in to witness. And also, finally, my lord, is the fact that nothing in the law, nothing in the act, nothing in the rules empowers a judge to make adoption order and papers without anybody making submission before him. That is why the procedural irregularities in this case might not be of equal force with the case of J minor, but they might not be the same, might not share the same feature with the case of J minor, but they are of equal force with that case.
Well, can I test that proposition?
Yes.
We don't, I think, need to go through all the authorities.
Yes, my lord.
But I think I'm right in saying that in those cases you cite, had the procedural irregularities not taken place, it is possible that the adoption order would not have been made. In the current case, Mr. Ijeze, it seems to me at the moment that given your client had not been given leave to oppose the adoption, and given all the history of the case, that can't be said here. That the adoption order, had the judge complied with the procedural rules and just allowed your client to be on the phone or to join a video hearing of some sort, the adoption order would have been made in exactly the same way. That's the difficulty, for my part, I think you face here.
Yeah, my lord, I have 2 points to make on that. First is that that is not a material consideration when we look at considering whether there is a requirement and there is an absolute requirement for a fair and regular process to be followed. That's one. But on secondly, my lord, if we then look at what heading J said in that case, she said that, just summarize, that apart from what happened at the hearing, there is, I'm trying to get it correct how she said it, but she's trying to suggest that there is nothing before her suggesting that the mother would have succeeded. Just like by way of summary. Maybe I might be able to get the particular place where she says that. So she expressed that view. But what she was doing was to make sure that everything was done properly.
But if there was a hearing at which where a substantive decision was going to be made about whether the children should be subject to a placement order, say, at which your clients had the right not only to attend but to make submissions through counsel or otherwise, and a judge just said, well, we're terribly busy and the pandemic's on, so we're just going to make the order, and that's too bad, then that would be a serious failure of natural justice, sort of natural justice, as it were, page 1, principle 1, that a party against whose interests a decision is going to be made has the right to be heard, to make submissions. But speaking for myself, that's a much more fundamental right than the right to attend a hearing and observe what happens. Like my lord, my present view is there was a procedural irregularity in this case, but I don't think you can lump all procedural irregularities together as being of equal gravity.
Yes, man. I'm sorry if I came across that way, but I try to identify the effect of, because it's going to be the judge by the effect. What the procedural irregularity did was, first, apart from the fact that it denied the mother the opportunity to air her view as to the existing or proposed arrangement for her children.
Well, now, just a moment. She could not have raised her views about the proposed arrangements, except on the question of contact.
The contact,
if,
yes.
If invited.
Yes, if invited. Okay, yes, my lord. Then the second big part is that it also denied the mother the opportunity to know or witness how her children were taken out.
Well, that's undoubtedly that she should have been entitled to that, and that's why, for my part, at the moment, I think there was an irregularity.
Yes,
You're asking us to revoke the adoption order.
Reason I say that, my lord, is that if it's not being revoked, my lord will see that in the authorities, there are ones that children have been over 18 and they came back and said, no, please, I want this to be revoked. In one of them recently, they were successful. One was 18. The other one wasn't successful. It was about over 30 or thereabouts. So what we're looking at is that what will happen to the children if they grow up tomorrow and look back, and they will be upset with the system. And my submission is that the court has an obligation to protect the integrity of our system. And that is the point Heading J was making in her statement, making reference to the integrity.
I'm sorry to keep breaking in, but could I ask, just to test what you're saying, let us assume that there was a procedural irregularity,
yes,
but change the circumstances a little. to the situation where the mother concerned does not object to the adoption, but wants to be there to witness it. And then the matter proceeds otherwise as it did. Now that would be the same procedural irregularity as, if there is one, is present in this case, because it would still have proceeded in the wrong way.
Yes, my lord. Yes, my lord. That's correct, my lord.
But there would be no question there of denying the mother the opportunity to object, because there wasn't an objection. So there's still a procedural irregularity, but it would be common ground that the outcome would be adoption.
Yes, yes, my lord.
Now, do you say that even in those circumstances, the procedural irregularity without any consequences is enough to say that the adoption should be revoked?
Yes, my lord, in this case, just to depart a little bit from my lord, forgive me, my lord, is that there is a consequence. Not in terms of making the adoption order because she has been refused leave to oppose making the adoption order. The consequence is that it has touched on the integrity of our judicial system.
Well, can I press you on my lord's point?
Yes.
If taking my lord's premise, isn't it an equal, to use your phrase, doesn't equally undermine the integrity of the system, or not? What do you say? Suppose the mother did not want to object to the adoption.
Yes.
Wanted to attend the hearing, and didn't in the same circumstances. Would it still be this court's obligation to revoke the adoption order in those circumstances?
Well, just to be clear, in circumstances where the mother
does not oppose the adoption.
Yes, but attended or did not
wanted to attend.
Yes.
The judge, exactly the same thing happened.
Yes.
The judge went ahead and dealt with it on paper. Would this court still be under an obligation in those circumstances to revoke the adoption order?
And that would be subject to one point, is who was in court when the order was made.
So assume exactly the same. Assume that nobody in court. Judge makes it exactly as he did on paper.
Yes.
But the mother hadn't wanted to oppose the adoption.
Yes.
Do you say that was equally irregular, so as to oblige this court to revoke?
Yes, my lord. Yes, my lord. I say that because there is nothing in the act, in the law, on the rules that permits a judge to make an adoption order without any form of a hearing. Yeah. My lord, just to add one more point to the point made by Heading J, the similar point was made by the President, Sir Andrew McFarlane, in the case of a children remote hearing, we all know, and I said that is on page 4 of my speaking note. He says, paragraph 12 of that judgment, finally, in addition to the need for there to be a fair and just process for all parties, there is a separate need, particularly where the plan is for adoption, for the child to be able to know and understand in the later years that such a life-changing decision was only made after a thorough, regular, and fair hearing. My lord, to sum up my position on this point is the fact that my submission that the irregularity that happened in this case is fundamental. In the word of, to use the word of one of the judges, in the case of Arrow adoption and worship, that it goes beyond the cosmetic.
And you say we should set it aside without considering other factors, such as, for example, the Section 1 provision. Do you?
I say, in asking my lord to set this aside, I'm asking my lord to consider all the factors. No one factor trumps each other. But, my lord, we now weigh all the factors together.
Forgive me. Are we not? coming to a decision relating to the adoption of the children.
Yes, my lord.
So in those circumstances, we have to consider the welfare of the children throughout their lives is our paramount consideration.
And in making that decision, my lord, we then consider which of the factor is inalienable. That is the factor that will trump all the consideration.
What is inalienable?
The fact that the system that led to the adoption must be regular. If my lord finds that system is regular, because my lord, that is the foundation.
So you're saying that the inalienability, your point about the process,
yes,
is even more fundamental than the provisions of Section 1 of the Act.
That due process form part of Section 1 because it's also in their own interest, in the best interest of the child, to use Article 3 of the United Nations Convention on the Right of the Child, the world. It is in the best interest of the child for the child to be adopted by due process of law. So that should trump every other consideration within the welfare.
Without considering, in every circumstance, you're saying, without looking at the rest of the facts of the case, that trumps everything.
No, that would be considered. The same thing that Heading J did. In her opening statement there, she also refers to the impact it will have on the children, impact it will have on the parents. Of course, my lord, I expect my lords to consider all those factors.
But how, forgive me for interrupting.
Yes, my lord.
But how, we don't have the information, if you're right, we don't have the information on which to gauge whether or not balancing all the factors out. It would be right to revoke the order, do we? Because there are obviously factors the other way.
Yes.
Well, there must be. Everything we know suggests these children were rightly placed for adoption. That's the earlier decisions.
Yes, my lord.
That the adoption, the actual placement was in their interests.
Yes,
and there's nothing that no possible basis for concluding that other than this procedural point, the adoption was contrary to their interests. So, but you're inviting us to disregard all that on the grounds of the inalienability of the right to a public hearing, or an open hearing.
My lord, perhaps if I could rephrase, my lord, I'm asking my lords to consider all the factors, but for my lords to give more weight to the integrity of the process that led to the adoption, because it is inalienable. At the end of the day, if the revocation is also, I'm trying to be careful because we're not looking into the substance, but if the revocation, if the revocation is granted, the children will still be with the adoptive parents. What it does is, my lord, I urge my lords to look into the effect of revocation, because that would then help my lord in balancing the factors, the welfare checklist. If a revocation is granted, it returns to the status quo, and the status quo was the placement order. The children will still be in their current placement with the adoptive parents, who were the local authority foster parents. So if the adoption is revoked, the children will not be taken away immediately from their adoptive parents. They still remain there, but the status will change. It will no longer be adopted. It will then be under a continuing placement order. That placement order still remain valid. I don't know, my lord, if I was able to answer my lord's question. One final point I wanted to make under issue 2 was, my lord might have seen it in my learned friend's skeleton argument, the idea of the fact that there is so much high bar in order to revoke or set aside or quash an adoption order. And I made that point in my speaking notes, that high bar only applies if the adoption was lawfully and regularly made. And that is what the authorities are saying. If my lord agrees with me that the adoption order was not regularly or validly made, then we don't have to cross that high bar, my lord. So in other words, we have to, our threshold for succeeding should be a low threshold. Thank you, my lord. My lord then leaves me with the three, based on the submissions I've made on issues 1 and issues 2, my submission, and I'll humbly be urging my lord to revoke the adoption order. I know I've taken so much time, my lord. I don't know whether my lord want me to speak about issue 3, which is ancillary, and
My
issue
lord,
4.
if my lord would just permit me to ask a simple question on question 3.
Yes.
Has the Court of Appeal ever ruled on whether, I haven't had a chance to check with the authorities, has the Court of Appeal ever ruled on whether, the circumstances in which you should appeal as opposed to rely on inherent jurisdiction?
My lord, the authorities I've read, no one has, I have not seen any...
A series of first instances. I wasn't sure, I think there may be a reference in the Bosnian case, which I ought to remember, of course, because I was in it, but I can't remember now, whether the court, in the Court of Appeal in that case, authorised or approved of the practice of using the inherent jurisdiction.
Maybe something that my friend...
Shall we perhaps, with the law permits, see what Ms. Cheetham says about that?
Yes, on that point.
My lord, it's in Webster.
Webster, thank
in
you.
fact,
All right, thank you.
Because my lord will record.
Okay.
it.
Well, so in Webster, this court has said it's okay to use the revocation, use the inherent jurisdiction to revoke.
My lord, yes.
Thank you.
So I don't know if my lord will want me to make more points on issue 3.
Not for me.
No, thank you.
Okay. Thank you, my lord. On it just, if my lord permit me, is what I say on paragraph 5. That's page 6 of my speaking notes about in case if my lord will want to issue a clear guidance on that. What I have proposed was that in cases of fundamental procedural irregularity, then it should go to the High Court. And in cases of mere irregularity, then appeal route should be...
Yes, you distinguish mere irregularity from serious irregularity.
Yeah, serious one. Because it's important we do that. Because there are irregularities, there are serious, and there are mere irregularities. They're not serious. On issue 4, just one point I need, as I made on page 7 of my speaking notes. The guidance in RA children, remote hearing, is a good one. It's a sound one.
So no need for further.
Yeah, no. With caution, I'm saying that. The reason being that from what we have seen in this case, there might be need to clarify further, because my lord, we see that in that case, the guidance wasn't too firm as to what a court should do. It left it to the discretion of the judge, but giving some guidance on how to go about it. I would suggest that when it comes to final adoption hearing, it should be face-to-face in court. Then only, because I'm learning from...
You mean face-to-face as opposed to
remote?
Virtual.
Virtual. I want to say in
real
court.
life.
In real life.
Then remotely...
Like this.
Yes. Remotely, in the cases of urgent cases, then remote hearing by any means, video, telephone, could be deployed. But one needs to be careful that all of us are not the same in terms of technology. And also, from my perspective, I've seen some clients who also struggle with when you're trying to set up.
Yes. Well, we don't. Of course, I'm familiar with those issues, but we probably don't need to go over all that in this judgment. Your basic point is you invite this court to say loud and clear that adoption orders should be made at face-to-face hearings.
Yes, my lord. Thank you, my lord. Unless there is another way I will be of assistance. Those are my submissions.
You've been very clear and concise. Thank you very much.
Thank you, my lord.
Ms. Cheetham.
My lord, may we deal first of all with the procedural irregularity point, and the reason that we say that a judge in these circumstances has the ability to dispense with the attendance, in fact, of one of the parents. My Lord, it's based on this. If the court doesn't have the power to do that under the rules, it could create a situation where effectively a natural parent, has a veto over that hearing taking place. So there must be circumstances.
Sorry, why? Don't understand.
Why can't they attend, instead of a virtual hearing, why can't they attend a virtual hearing?
No, my Lord, of course they can, and my Lord, they should. So we're not seeking to say for one moment that this should be done regularly or that it was it set some sort of precedent. We say this was done in extreme circumstances in the middle of the pandemic. But it must be the case that the court making an adoption order can, if necessary, dispense with the attendance of a parent or excuse them from attending.
But the point I made to Mr. Izay was that the power to excuse is a power to relieve someone of an obligation.
Yes.
And that's not how this statutory provision is couched. The provision in the rules is couched. It's a permissive. You can't dispense with some permission.
But my Lord, it can't. Neither can it be, in my submission, an absolute right for a parent to attend that hearing.
Well, assuming we can have let's forget telephone hearings. Assuming you can have a virtual hearing by Teams, as happens up and down the country all the time now.
Yes.
The judge says the hearing will be by Teams. Then, and if the mother chooses not to attend by Teams or objects to the method chosen by the judge, that's a different matter. But he can't relieve her of her. He can't deprive her of the right to attend a hearing. He can say what format the hearing should take, but he can't deprive her of the right to attend it.
My Lord, no, not if a hearing is taking place, but there will be circumstances in which, for example, it may not be appropriate for a natural parent to attend that hearing in person or even by Teams. So, for example, if there are two parents and one is a risk to the other one, that's not
insuperable. Again, that's something which has to be dealt with. So if there are two parents, one of whom is allegedly violent to the other person doesn't want to. There's difficulties about them being in the same room. Well, those are problems which the religiosity difficulties, but the judge would not be entitled to just set aside the right to attend.
Well, my Lord, if in those circumstances there was a father with parental responsibility and a mother, and they both wanted to attend.
When you have a hearing, I'm just thinking off the top of my head now, Mr. Cheatham, what you do is you set up the hearing, and you have the mother in one part of the building, the father in the other part of the building, and you have the mother attending part of the hearing and the father attending another part. You do what you have to do with them, each present separately, before making the order. None of these issues are insuperable.
No, and my Lord, but what we say is that there can't be, the jurisdiction to make that order, which is Hamlin Friend refers to it, doesn't arise out of the presence of one of the natural parents.
No. Jurisdiction to make the order doesn't arise, but the right to attend is a right to attend. It's unqualified.
And how does the veto arise? I don't myself understand that submission, particularly where you contemplate, never mind telephone hearings, but you have a virtual hearing, so one of them's in a building somewhere else.
Well, my Lord, the difficulty is that if one of the parents is insisting on not insisting, but wants to exercise that right to attend.
Yeah.
But for example, they are overseas or then it can't, the actual presence, which as I understand it.
Well, if you're talking about a face-to-face right,
yes,
I understand your argument.
Yes. But
if once you allow for the contingency, particularly in the sort of extreme circumstance of potential violence, once you have the contingency or the opportunity to have the hearing managed in the way we're all familiar with,
yes,
how is there a veto? Date is fixed, time is fixed, arrangements are made. If the party doesn't come, there's no veto. If they come and disrupt, that can be dealt with. Where's the veto?
My Lord, yes, I
You see, the way, yes, it's
the notice of hearing goes out. And once the notice of hearing goes out, the mother's entitled to attend. But the mother can't say, I'm sorry, I'm not coming that day because I'm going to be abroad for 6 months. Please adjourn.
Yes.
Once the hearing has been set up, as my Lord says...
My Lord, yes. So I suppose the point, my Lord, is this, that it cannot be that effectively the control of the hearing is handed to the parents. That's not what the issue is.
It's like any other hearing.
So, yes, and so in that sense, in certain circumstances, it must be possible to dispense with attendance.
Well, I'm not sure about that. It depends on the reason.
Yes.
We've been discussing disruptive or violent parties. No suggestion of that. Yeah. And attend clearly doesn't mean, at least I don't think it means, absolute right to attend physically. That otherwise, I suppose, every hearing of this type or any family case which took part in the pandemic other than face-to-face would have been invalid. Well, we're not going to hold that. But what Judge Booth seems to have done is simply said, well, this is going to be a hearing in private, i.e. It's a decision I'm going to make on the papers in my room. Can't really be described as a hearing at all. Now, understands the pressure, but if you're to say that there is no procedural irregularity at all, you're saying, in effect, that notwithstanding the terms of FPR 1415 and 1416, a judge can simply decide to go ahead with make a decision on the papers, described as a private hearing, but with nobody in the room except him, and that is perfectly all right. It doesn't seem to me that it is perfectly all right. How serious it is, what the consequences should be, is a different matter. But I mean, to say that that's perfectly all right, it isn't even an irregularity, seems to me very odd.
Well, my Lord, we're not saying that it's perfectly all right. It's the issue, it seems, perhaps reframing it slightly, is this. Was it a proportionate way of dealing with this issue, given the seriousness of the order which was about to be made, despite the fact that there had been 2 refusals of permission to appeal on substantive matters and so on? And secondly, was there an alternative which could have been offered, which would have met the requirements, and that would have been the telephone?
Well, why couldn't there have been a video? Why couldn't there be a phone hearing? Why couldn't the hearing have gone ahead?
There was a phone hearing arranged.
Yes.
And then it was dispensed with.
Yes.
Why? Well,
So, my Lord, we're not saying there are never circumstances in which the parents' attendance. We maintain that the parents' attendance cannot be the basis of requirement for the order to be made.
Well, that's a question of validity, and
yes.
Mr. Ijezi didn't actually pursue the argument that the order is simply a nullity, as though it had never happened. And speaking for myself, I think that's unsustainable. We're at the moment on the question of procedural irregularity, and the significance of that, as it seems to me, is that Sir James Munby said in Re C, or whichever letter of the alphabet it was, if you are making an application to revoke a final adoption order in circumstances where there has been no procedural irregularity, you have a very steep hill to climb. Only the significance of this, perhaps, is that that special rule doesn't apply. But if there was a procedural you're going to go on to say it wasn't so serious or fundamental as to mean that Mr. Justice Peel should have, or that we should, overthrow the order.
My Lord, yes, and my Lord, just to be clear, and we say this in our skeleton, there are, of course, even in the circumstances of this mother at this hearing, there are very good reasons which relate to the welfare of the children why a parent should be present when that order is made.
Yes.
And one of those reasons is so that the child knows
Yes.
in the future.
Well, you acknowledge that, exactly.
Yes, that the parent cared sufficiently about them to be there at that hearing, despite the fact that they couldn't be heard. And, my lords, we don't say anything to take away from that very important right, which in normal circumstances...
And the practice up and down the country, Ms. Cheetham, as I understand it, from my experience in these cases, is that where the parents indicate they are going to attend, the applicant's attendance is excused.
Yes.
And then there is a subsequent event at which the formal event, sometimes called an adoption ceremony, a few weeks later, when the adopters and sometimes the children attend, and the children attend with the judge.
And of course, there are important reasons for the parent as well to be there when that.
So the fact that the courts up and down the country are used to orchestrating it in that way indicates the importance of the fact that parents are entitled to attend.
Yes.
Birth parents are entitled to attend. The actual formal making of the order.
And my lord, the other matter which we don't disagree with is that where an order of this seriousness is made, again, in the circumstances where there have been previous refusals of permission to appeal, the parent is still entitled to know exactly why the order has been made, and perhaps in this particular circumstance, why the judge decided that the mother's attendance wasn't...
It's a long-standing... It is. I haven't been able to say to go back, because you can't get the old adoption rules online, but certainly it goes back to the 76 law, and probably before that the parents had to be present.
Yes.
Were entitled to be present.
So, my lord, where that leaves us in terms of the procedural irregularity is that we say there must be circumstances in which the court could dispense with the attendance of a parent. Whether that should have been done in this case...
Well, could I question that? I've read your skeleton with interest, and of course, my lord, and you are much more familiar with the relevant rules than I am. But you seem to be pointing to the broad and general powers of case management.
Yes.
Let's look at 1415 and 1416. 1415 requires the court officer to give notice to the parties.
Yes.
Right. So there's an obligation to give notice so that they may attend. 1416.1 first half, before you reach the and, we think we looked at, and it's an unqualified right to attend. Well, that's the natural meaning of it. And then there's a specific provision for the court's powers on attendance. 1416.7. Court may direct that the applicant or the child need not attend. Now, if the general case management powers allowed the court to direct that the mother need not or cannot attend, would that not conflict with the specific limit placed on the general case management powers set out in subpara 7?
Well, my lord, I say no for this reason. There are certain circumstances, not this case, but in other cases where a parent might say, well, I'd like to attend, can you set up the hearing, please? The hearing is set up, and then they say, I'm sorry, I can't make it.
Yeah, but that simply means that the parent is not exercising their right to come. That's not a direction by the court.
But if they say, I would like to come, but I'm not able to on this occasion, and the question is then on how many occasions would the court adjourn?
Well, but that applies to just about every type of hearing, in criminal, civil, family. party has a right to attend, sometimes a duty to attend, and then they say, in terms of real life hearing, oh, I'm not very well, or my back's gone, or I've got a letter from my GP saying that I'm not fit to attend work, or I've got childcare issues, or whatever. And the court has inherent jurisdiction in every type of case to say, well, I'm sorry, we're going ahead anyway. Likewise with disruptive parties and so on, all that we understand. But in the face of what's on the face of it, a mandatory specific order in the rules that any party may attend, where you haven't got any suggestion of disruption or violence or something like that. Seems to me, it's not my field of law, but on the face of it, they have a right to attend. And attend, I think we're all agreed, Mr. Ejezi didn't say it's an absolute right to attend physically at a time when physical face-to-face hearings were impractical. But a right to attend, at least by phone, by video at a time when that was practicable, not to be shut out altogether.
And my lord, on the first occasion when this hearing was being heard, and of course I have to accept this case was listed, a telephone hearing was set up, and on the face of the order, it's not at all clear why that telephone hearing was not proceeded with, and that's the situation that applies in this case.
These, of course, there are different types of adoption, and these rules apply to all types. So it applies, for example, to a step-parent adoption, which will not have been preceded by a placement order, so a non-agency adoption. And in those circumstances, I've conducted final hearings of adoptions in these circumstances. Sometimes the birth parent, the other birth parent, attends and under the rules, because of the way they're structured, would be allowed to oppose.
Yes.
So you have a contested hearing in those circumstances, or may want to be heard on some ancillary matter.
Yes.
So this has to be quite a flexible rule.
Yes.
But the right to attend is unqualified, it seems to me. The right to be heard on the making of the order is qualified, because of the placement. If they've not got leave to oppose after the making of placement order, they can't be heard on the question of whether the order can be made.
And of course that application had been dealt with.
Yes, but the fact that that's qualified, in a sense, rather underscores the right to attend. It's a right to attend even if you can't be heard.
Yes.
And this, as I said, this has existed throughout legislative history. So when placement orders are introduced, when freeing, I don't want to go into history too much. Before placement orders, as you just about recall, Ms. Cheetham, there was freeing for adoption, which my lords may remember in the dim and distant past. In those circumstances, the question of a parent's consent to adoption was dealt with at a much earlier stage, and the child was freed for adoption, and the parental responsibility was then removed. And such parents did not have the right to be heard, but could attend, as I recall off the top of my head. So this is clearly Parliament's deliberate intention of approving through approving of the rules that this should persist.
My lords, yes, and I don't propose to address my lords any further in relation to that issue. My lord, in relation to the contact issue, there was no, well, the final care plans, as my lord might expect, contained provisions in relation to contact. That was for letterbox contact,
yes,
both ways. So those were in place. My lord, the case had been dealt with, as we know, by Sovereign Judge Booth on the 21st of February on the application for permission to oppose the adoption. There was no application for leave at that stage to make an application for adoption. And in terms of the realistic prejudice to the mother as far as contact is concerned, of course, the position doesn't change. She would have required leave in any event to make an application.
And the point made by my lord about Section 51A is a good one, isn't it?
Yes.
Because it's right that you can apply for leave at any point.
Yes.
Under 51A.
So in that.
And I suppose it could be argued that that someone who'd not been able to attend a hearing of this sort, for the reasons that occurred in this case, might have a stronger argument on a 51A application.
Yes.
Afterwards.
So, my lord, again, I don't propose to say any more about that. We say that the issue in this case is not about what might have been said in relation to contact, because, again, whilst it's there theoretically, the practical effect of it in terms of the mother's situation was in fact no different whether she was to make an application before or after the order was made.
Right.
My lord, I don't know whether there are any other specific matters in relation to those issues which I can assist with. My lords, you have our skeleton in relation to some of the secondary issues.
Yeah, well, the revocation, for my part, the key question is whether or not, assuming there was an irregularity, whether it was on a scale which obliged Mr. Justice Poole to revoke the appeal. Oh, sorry, I ought to know that. Mr. Justice Peel, I apologise. Mr. Justice Peel to revoke the order, and that we should therefore do that.
My lords, our submission in relation to that is really quite straightforward, and that is this. The procedural irregularity, if there was one, was not such that it could or should lead the court to set aside the adoption order. And my lord, the reason that we say that is that when one looks at the history of this matter, it wasn't that the mother's rights to oppose the adoption had been significantly compromised. In fact, she had exercised her right to oppose at every available opportunity. She had made applications for permission to appeal, both the making of the care and placement orders and indeed the application for leave to oppose the adoption order. The children have been placed, child C in a concurrent placement during the course of the care proceedings with the current adopters, and children A and B following shortly thereafter during the course of the proceeding. And so certainly insofar as...
It's separate placements, are they?
In the same placement.
Same placement, good.
Same placement. So they, children A and B moved into child C concurrent,
yes, that's right.
concurrent placement. So child C has never known any other family than the family that they are currently placed with. Those children together have the opportunity to be brought up in their sibling group, and those were matters which were considered in depth in terms of the proposed placements by His Honour Judge Booth, both in the original judgment and also in the lengthy judgment which he gave in relation to the application for permission to oppose the adoption. And in our submission at each stage, whatever the criticisms may be of procedural irregularity in terms of the machinery of the actual adoption order itself, at those stages he certainly gave full effect to Section 1, considered all of those matters which needed to be considered. And in those circumstances, the disruption and the anxiety which would be caused to the adoptive parents and the consequences, knock-on consequences of that for the children by the revocation simply are not merited by the procedural irregularity which took place.
Well, there's no indication that if we revoked this, if we decided that the adoption order should be revoked, so the case reverted to a placement order, there was another application to adopt, another hearing, there's nothing to indicate that the outcome would be any different, is there?
No, and in fact, in our submission, it's the reverse. Given the submissions which were put forward at the February hearing in relation to what was said to be a change of circumstances. So, my Lord,
You say, I suppose, there's a very substantial difference between a final adoption order made in the absence of a party who had a right to be heard and a party who had a right to attend.
yes, that must be absolutely correct, because of the, as we've already discussed, the rationale for permission to attend is completely different from that where a parent has a right to be heard, a right to attend and say, my circumstances have completely changed, this is the change, and I can cross that very high bar in order to have leave to oppose the making of the adoption order. That opportunity had already been taken, it had been rejected by the judge who had the care proceedings, and permission had been refused by the Court of Appeal.
Yes.
My Lords, we develop in the skeleton at my Lord's invitation our thoughts about the circumstances in which the inherent jurisdiction should be used to revoke adoption orders. My Lord, in a nutshell, the anxiety is this, I suppose, that in a piece of legislation which is so carefully calibrated as the Adoption and Children Act is, to provide a natural parent at every stage with the right to oppose the making of such a serious order, and carefully calibrated so that there is, as I think Lord Justice Thorpe referred to it, an ever-increasing hurdle the closer to the final adoption order, and certainly after the placement of the children, that to say that there is a process, a parallel process effectively to that of the legislative process, which allows a natural parent to go to the High Court without leave and apply to revoke the order, can't, in our submission, be correct.
Is there any suggestion this power is being used excessively or abused? I mean, the High Court, any such application will be listed before a full judge of the Family Division, who would obviously deal pretty summarily with any spurious applications. The cases cited, the cases we've got, Justice Hayden, Justice Tice, those are exceptional cases, aren't they?
My Lord, they are, but my Lord, it's impossible to say how many other cases there are which are being used. I suppose the worrying thing is that there is a practice which has developed of almost looking at these situations as a sort of either-or choice. You could either ask for permission to appeal, or you could ask to have the order revoked. And I suppose the concern is, my Lord, that it may result in a situation where, for example, an appeal is very, very plainly out of time, then the alternative process is being used. And Lord, we referred to the observations in Re B, which were that there are two circumstances in which an adoption order might be revoked, and those are in applications either on appeal or certiorari, a quashing order. And of course, a quashing order there would be a permission stage for that,
yes,
filtering. The difficulty with not having a permission stage is that the whole stability of a potential adoptive placement years down the line can be thrown into chaos.
So you're saying the inherent jurisdiction should not be used to circumvent the permission stage required of an appeal?
Precisely, as it couldn't be in judicial review, because an application for a quashing order would be unlikely, or permission would be unlikely to be given, for example, if there was a route of appeal which was open.
Yes. And I think it's you who suggests, isn't it, that the exceptions would be those people who can't appeal.
Yes.
So that would be the adopters themselves who might exceptionally want to set aside the adoption
Yes.
order, or the child
Yes.
in very exceptional circumstances.
Yes. And those cases, my lord, where there is, and Rio we say is one of them, where the adoption order itself is perfectly lawfully made. There's no issue as to procedural regularity. There's no grounds for an appeal. But it was made in circumstances where actually, in Rio, it wasn't necessary and wasn't wanted, and should never be made.
Rio.
Rio is Lord Justice Mumby, the artificial insemination.
Yes.
So
Generally speaking, although there's no permission stage, judges of the family division would exercise their discretion and case management powers would deal pretty summarily with cases that had no merit, wouldn't they?
My lord, I would think so. Not having made or be in the habit of making those types of applications, but I would imagine so. But the difficulty is, of course, that with these cases, very often there is no public funding available.
Right.
And so the application actually may be made by a
litigant in person.
And they do present a challenge, and they present a challenge to the adoption agency as well, because there is the difficulty always about the information which is given to the adoptive parents about this application, which has been made in respect of their legal children. So it's not simply dealt with as it would be if there was a leave stage, where the only person who would be making the application and would be in court would be likely to be the person making the application. And difficult decisions have to be made about information which is given to the...
Well, that might be a reason for saying that the more flexible approach to the family division judge would be better suited than filing a notice of appeal in the Civil Appeals Office.
Well, my lord, it's difficult to conceive of circumstances where the permission would be given on an appeal, which would be not. Sorry, I'm not phrasing myself. Permission would be given on appeal, when permission wouldn't be given for example, a quashing order. My lord, it's a difficult issue which we've grappled with. I hope we've been helpful. Can I assist any further?
No,
Thank you very much. Ms. Moody.
Thank you, my lords. The Guardian's position can be summarised as this. Firstly, we say that there was no procedural irregularity. I know that my lords have ventilated that issue already. And secondly, if there was a procedural irregularity, it doesn't meet the high threshold that the authorities establish. My lords, I'll certainly try and avoid those arguments already put before the court when dealing with the first point on behalf of the Guardian as to whether or not there has been a procedural irregularity. We recognise, of course, in our skeleton argument that the rules on this are clear, both the family procedure rules and also the President's guidance, which says clearly at paragraph 10 that the parent should be allowed to attend the final adoption hearing. And they are referred to in the skeleton argument at paragraphs 8 and 9.
Yes.
My lord, what I raise on behalf of the children is whether it is an absolute right that a parent should be entitled to attend a hearing, or whether there are any circumstances which would mean therefore that it is a qualified right, which would enable a trial judge to dispense with the attendance of a parent. My lords, I wonder whether there are some exceptional circumstances, and I phrased in my own mind the following. A parent who wishes to delay the making of an inevitable adoption order. For example, a parent who is out of the country, in a village, in a far corner of the globe, would be unable to attend the hearing.
Well, Miss Moody, with respect, we've tossed this back and forth with Miss Cheetham. It's an important point. But could we say, if you have a point to raise which Miss Cheetham didn't think of, then please do. But I think you can see the indications we gave to Ms. Cheetham. And
My lord, yes, sir.
It's perhaps more useful to concentrate on, if there was any irregularity in this case, then how serious was it and what should the consequences be?
My lord, I know from the authorities that we have that there is reference to a cosmetic irregularity, which in the context of an adoption case doesn't seem a very attractive word to use. But of course, in the circumstance of this case, I would argue that the procedural irregularity was of little consequence to the mother and indeed to the children. And I say that for these reasons. I distinguish the case before my lords with the authorities that we have, where, for example, a parent has not been given notice of the hearing. A parent has not been allowed to agree or indeed withhold consent to an adoption. Those cases also concerned a situation, I'm talking about the Bosnia case in particular, where a guardian hadn't been appointed for the child, and therefore the child's views and indeed the child's welfare wasn't safeguarded throughout those proceedings. The case before the court now is very different, of course. The mother's position, her wish to oppose the adoption order was well heard. She was represented. The judge gave a judgment on that. The mother sought leave to appeal to the Court of Appeal in relation to that. So, in the circumstance of this case, the mother has been given a right to be heard, and indeed has been heard. The issue for the mother, of course, is that she was not able to attend the adoption hearing, either virtually or indeed in person. And of course, in the circumstance of this case, the children's welfare has been very properly safeguarded through the appointment of a children's guardian and children's solicitor throughout. So for the reasons I set out in the skeleton argument, in my respectful submission, this case doesn't come anywhere near to the exceptional circumstances that have been set out in the authorities that we have before the court. There is no, to use the words, fundamental breach of natural justice. The mother had no further opportunity to be heard on her issue as to whether or not an adoption order should be made. It was inevitable. And my lord posed the scenario as to whether or not... Right, I've lost my train of thought. If the mother wanted to attend and was unable to attend, that of course was the position here.
Well, presumably you would support the distinction I suggested earlier between breach of a right to attend a hearing and the breach of the right to be heard. And the breach of the right to be heard is plainly much more serious.
My lord, yes, and had the mother attended by telephone, as was the intention of the court, the outcome would have been no different, in my respectful submission. The mother had no right to be heard. The court had before it all of the relevant paperwork. It had the Annex A report, it had the statement of the social worker. My lord raised earlier the contents of the Annex A report, and we know from the Practice Direction 14C and the Annex to that the Annex A report was very clearly set out the views of the parents in relation to contact. So that information was already, before his honour Judge Booth, when he made the order. So, my lords, forgive me, the point I was wishing to make is that this would have made a little difference to the outcome if the mother had been able to attend by telephone, and therefore this case
Would have made any difference. Would it have made any difference?
Well, my lord, no, and in those circumstances, one cannot conceivably argue that this amounted to a fundamental breach of natural justice. My lord, I set out towards the end of the skeleton argument points that my lord had referred to towards the end of his submission in terms of whether or not the appeal route is the most appropriate route, or indeed the
Well, we have quite extensive comments on that.
My lord, yes. I make some observations on behalf of the Guardian and also in relation to remote hearings as well.
Yeah. Thank you.
A distinction is to be made. Of course, we're not in a position now, thankfully, where we have to rely on telephone hearings. Face-to-face hearings, albeit virtually, can be accommodated. But perhaps a distinction is to be made where there is a contested issue or where a parent has a right to be heard, that there may be preference for those to be face-to-face as opposed to...
I think that may be in the view of judges up and down the country, because there was in the immediate period after the pandemic started, there was a significant reduction in the number of adoption orders made, adoption hearings taking place. It may well be that judges took the view they've got to be face-to-face, so consequently we won't do them for the moment, which caused, of course, other problems.
My lord, I don't know if there are any further arguments set out in my skeleton that I can develop any further. I know
Thank you very much. Set them up very helpfully.
Got to my feet.
Yeah, right. Thank you very much. Smoothly. Mr. Jesse.
Yes, my lord. I only will have one point to respond to. That's the point about Section 51A4, subparagraph 4C in particular.
My lords won't have that.
Yes, my lord.
It's not in the bundle, is it?
No, it's not in the bundle, unfortunately. It's not in the bundle.
Well,
yeah.
Shall I pass it along the row?
My Lord Justice Baker has already mentioned the point I wanted to make about the requirement to the requirement of leave.
Yes.
Yes.
My lord knows it.
I'll do it from memory.
So Stephen and I will look it up.
I could look it on my phone, but I'm not sure my lord will approve.
Yes. Just one point I want to make is that the fact that there was this postulations as to whether the rights under Section 51A how that could be used by the mother and how could be the effect of that.
The point was she would have the power to apply for leave after the adoption order was made, and I observed that she might have a stronger argument in these circumstances.
Yes, but one more point I need to remind my lord is that she doesn't have a right
to apply for leave.
Yeah, she had to apply for leave.
Yes. Yes. Yeah, but her arguments on the leave application might possibly be stronger in these circumstances.
Yes, but my lord will also know that judges think differently. What my lord might have in mind might be different from what the family court judge might have in mind. This is the only point I wanted to let my lords know, so that at the point where my lords are considering the Section 51A point, that point is noted that mother didn't have or doesn't have.
Not necessarily the case that a judge would agree with my observation about a stronger argument.
Thank you, my lords. That would be all for me.
We'll just retire for a moment and see whether there are any further points we want to raise with any of you, and how to proceed from there. We are in a position to announce our decision today. We consider that there was a procedural irregularity in this case, but that it was not an irregularity which would have justified the revocation of the order made by Judge Booth. Accordingly, our decision will be that the appeal is dismissed. In deference to the helpful arguments of counsel and the importance of the case, we will give our reasons in writing to be handed down in the usual way. In due course, we will send out the judgment to counsel, not for re-argument, but for correction of typos and so forth. We are very grateful to all counsel for their concise and helpful submissions.
Nice to meet you. Yes. Yeah. Take care. Bye-bye. Thanks very much indeed. Thank you. Bye-bye.
Make sure you've got everything.
Think so.
Think so. Thank you. Bye.
All right, David, just let you know it's reserved in 63. All right, my life, bye. All right, it's reserved, all right? Thanks, bye. Okay, bye. Hello. Oh, I don't believe it. You know, I've been to